Welcome to the debate. Imagine an AI model capable of autonomously generating thousands of hyper-realistic phishing emails a second.
Or, generating a fake audio clip of a CEO that instantly tanks a company's stock.
Exactly. And when that inevitable damage occurs, who is actually responsible? I mean, is it just the individual user who typed the prompt?
Or does the multi-billion-dollar company that built, trained, and released that model share the blame?
Right. And that underlying tension is exactly what we're tackling today. We are looking squarely at the newly released National Policy Framework for Artificial Intelligence.
Yeah, for those who haven't read it, this document is basically a comprehensive set of legislative recommendations. It outlines exactly how the United States plans to handle AI development, regulation, and integration moving forward.
It's essentially the master blueprint for governing a general-purpose frontier technology for the foreseeable future. And importantly, every single argument and critique we make today is drawn directly from the text of this proposed framework.
Straight from the source material, right?
Yeah. So the central question we're exploring is whether this framework's highly decentralized, innovation-first strategy, which relies really heavily on preempting state laws, utilizing existing regulatory bodies, and deferring to the judicial system, whether that strikes the right balance to maintain American AI dominance.
Or on the flip side, if it leaves dangerous gaps in oversight and accountability.
Right. And I'm taking the position that this framework gets it right. I see it as a highly pragmatic, minimally burdensome approach. It actively removes bureaucratic red tape while still deploying targeted protections for key rights.
And I'll be arguing that the framework's deliberate avoidance of central regulation, combined with its preemption of state laws, creates a massive structural void. I mean, it basically prioritizes shielding AI companies from accountability over ensuring comprehensive public safety.
Well, let's lay out why this approach is actually brilliant in its pragmatism. The framework recognizes a fundamental truth, right? If the United States wants to achieve and maintain global AI dominance in a fiercely competitive landscape, we can't be tripping over our own regulatory shoelaces.
Right, the whole speed over safety concern.
I wouldn't call it that, but it explicitly directs Congress not to create some massive new federal rulemaking body just to regulate AI. Instead, it relies on the agencies we already have.
Plus things like regulatory sandboxes.
Exactly. Sandboxes and industry-led standards. And it does something absolutely crucial. It preempts a chaotic patchwork of 50 different state laws to ensure we have one unified national standard for developers to follow.
But at what cost?
Well, it doesn't ignore safety. It champions surgical interventions like the historic Take It Down Act to fight deepfake abuse. It mandates commercially reasonable age assurance to protect kids online. And it includes the Ratepayer Protection Pledge, so local communities don't see their power bills explode when an AI data center moves into town. It's balanced.
I look at that exact same structure and see a recipe for a massive accountability loophole. Don't get me wrong, there are individual initiatives in this document that are undeniably good.
Like what?
Well, protecting seniors from AI-enabled impersonation scams, fantastic. Offering resources like grants and tax incentives to small businesses so they can adopt AI, great. But the core structural philosophy here is deeply concerning.
How so?
By actively preempting states from regulating AI development and then specifically shielding those developers from liability when third parties misuse their models, you've created a void. You're telling the states, you can't police the development of this tech.
Right, because it's a national issue.
Sure, but then you're telling the federal government, don't build an agency to do it either. Relying on a fragmented web of legacy agencies and pushing all the thorny intellectual property issues to the slow-moving courts, it just isn't sufficient for a technology that evolves by the week.
Well, if you're listening to this and wondering how the balance of power actually works here, let's unpack this idea of federal preemption, because I think it's one of the most misunderstood parts of the framework.
It's definitely the most controversial.
Right. Federal preemption just means a federal standard overrides state laws on a specific issue. And it is practically required here. I mean, think about it. You simply cannot build and deploy a generative AI model if it has to comply with one set of algorithmic safety constraints in California.
And a totally contradictory set in Texas.
Exactly. And a third set in New York simultaneously. A 50-state regulatory maze would functionally halt AI development in this country. So preemption is a practical necessity, but the framework is actually deeply respectful of federalism.
I'm not sure the states would agree with that.
Well, it doesn't strip states of all their power. It explicitly preserves their traditional police powers. States can still enforce laws of general applicability to protect children, prevent fraud, and protect consumers. They keep their zoning laws to determine where AI infrastructure gets built. It only preempts the areas that are inherently interstate, like the actual design and development of the models.
Yeah, that sounds completely reasonable right up until you read the specific directives regarding liability. The framework explicitly states that states should not be permitted to penalize AI developers for a third party's unlawful conduct involving their models.
Which makes sense.
But that right there is the crux of the issue. The document asserts that states can't regulate AI development because it's an inherently interstate phenomenon with national security implications. Okay, fine. But if states can't regulate the development of the models, and they are explicitly barred from penalizing the developers when those models are predictably misused by bad actors—
Well, a critical enforcement mechanism is lost. Is that what you're saying?
completely lost. You've stripped the states of their ability to hold the primary architects of this technology financially accountable.
I see why you think that, but let me give you a different perspective. And it goes back to basic, proven principles of liability in traditional manufacturing. I mean, think about a company that manufactures a hammer.
Okay, a hammer.
Right. If someone goes to a hardware store, buys that hammer, and uses it to maliciously break a window or assault someone, we don't sue the hammer manufacturer for the broken window.
No, we don't.
The manufacturer created a general-purpose tool. The user is the one who committed the crime. And the framework is applying this exact time-tested legal philosophy to AI. It explicitly directs Congress to avoid setting open-ended liability that could give rise to excessive litigation.
But
wait, let me just finish this thought. If you make AI developers liable for every bad actor who misuses their open source or commercial models, you'll bankrupt the industry through endless lawsuits. Instead, the framework addresses the malicious use directly. It mandates that Congress augment existing law enforcement efforts to combat AI-enabled impersonation scams and fraud. You punish the person swinging the hammer, not the forge that made it.
I'm sorry, but I just don't buy that analogy at all. Let me tell you why. A frontier AI model is not a hammer.
Functionally, it's a tool.
A hammer is a static object. It doesn't possess the capability to autonomously generate thousands of targeted phishing emails in seconds. It doesn't dynamically create hyper-realistic deepfake material of real people. An AI model is a dynamic, cognitive engine.
Fair point. The scale is different.
It's not just scale, it's capability. When you shield the developer from third-party liability, you completely remove the primary financial incentive for them to build robust safety guardrails into the model before they release it.
You really think they have no incentive?
If a developer knows the state cannot penalize them when their tool is used for unlawful conduct, what's stopping them from racing to deploy models that are increasingly powerful but structurally unsafe? You're relying entirely on post-hoc law enforcement, cops trying to catch the bad actors after the damage is already done, rather than requiring the developer to make the tool secure by design.
But if we agree that a 50-state maze of liability laws would destroy the industry, the natural question becomes, well, who is actually steering the ship at the national level?
Exactly. Who is in charge?
And the framework's answer to that brings us perfectly to its proposed federal architecture, because the framework is incredibly clear on this. It explicitly says Congress should not create any new federal rulemaking body to regulate AI.
Which is a staggering abdication of federal responsibility.
Abdication?
Yes. If you've preempted the states from regulating development and you refuse to create a dedicated federal regulatory body, who is actually in charge? The framework suggests we rely on existing regulatory bodies with subject matter expertise, but our legacy agencies are deeply fragmented.
They have domain expertise, though.
But how is a patchwork of existing agencies supposed to manage cross-sector frontier AI models? We're talking about models with massive physical footprints requiring enormous data centers, and models with severe global national security implications. You cannot manage a cohesive national strategy by outsourcing it to a dozen different agencies that were designed for a pre-internet, let alone a pre-AI world.
That's an interesting point, though. I would frame it differently. The reliance on existing agencies isn't an abdication, it is the ultimate pragmatism.
How so?
Why build a bloated, slow-moving new bureaucracy when you already have domain experts in the federal government? If an AI system is being used to diagnose diseases in healthcare, who better to evaluate its efficacy than the FDA? They already have the medical expertise.
Sure, in healthcare.
Right, and if AI is being used in high-frequency trading, the SEC has the financial expertise. To help these agencies adapt, the framework champions regulatory sandboxes. These are safe, controlled environments where companies can test new AI applications under agency supervision without the immediate threat of regulatory fines.
So they get a pass to test things out.
It allows the regulators to learn how the tech works alongside the developers. And regarding the massive physical footprint you mentioned, the framework addresses this brilliantly. AI requires massive electricity. To prevent bottlenecks, the framework streamlines federal permitting so developers can build on-site behind-the-meter power generation.
Oh, right, the data centers generating their own power.
Exactly. This means data centers can generate their own power instead of crashing the local grid. This accelerates the infrastructure build-out and ensures grid reliability. Plus, to protect everyday people, it adheres to the Ratepayer Protection Pledge. That ensures residential ratepayers don't experience increased electricity costs to subsidize this new AI construction.
But that infrastructure pragmatism is a compelling argument. Streamlining permits for behind-the-meter power generation makes logistical sense. But it also highlights my exact concern. Have you considered the national security implications of not having a centralized body?
The framework does consider it.
But if we are streamlining permitting to build dedicated power plants just to fuel these frontier models, we are acknowledging the immense, almost nation-state scale of what is being built, yet we have no central agency overseeing the capabilities of these models. How do you manage a technology that requires its own power grid without a centralized watchdog?
By ensuring the watchdogs you already have are communicating directly with the builders. The framework does address national security explicitly. It mandates that Congress ensure the appropriate agencies within the national security enterprise possess sufficient technical capacity to understand these frontier AI model capabilities.
But it's just consultation.
It requires them to establish plans to mitigate potential concerns through direct consultation with the frontier AI developers. You don't need a new, public-facing regulatory agency to achieve high-level security. You need your existing intelligence and defense apparatus to interface agilely with the private sector. It's fast and effective.
Agile, perhaps, but it relies entirely on voluntary consultation and industry-led standards, which frankly brings us to how this decentralized, hands-off oversight handles the most valuable asset in the entire AI ecosystem.
Intellectual property and training data.
Exactly. The framework's approach to creators and free speech perfectly illustrates the danger of this architecture.
I'd argue the framework's stance on intellectual property is deeply respectful of existing legal traditions while acknowledging the novelty of how AI learns.
Respectful? It basically lets them scrape everything.
While it states clearly that the administration believes training AI models on copyrighted material does not violate copyright laws. However, it respectfully acknowledges that arguments to the contrary exist. So rather than having Congress clumsily rewrite copyright law overnight, it explicitly supports allowing the courts to resolve this issue.
Which takes forever.
It tells Congress not to take actions that would impact the judiciary's resolution of whether training constitutes fair use. It's respecting the separation of powers. Furthermore, it does propose strong, targeted protections where they're needed most. It calls for a federal framework protecting individuals from the unauthorized distribution or commercial use of AI-generated digital replicas.
Right, protecting people's voice and likeness.
Exactly, and it suggests enabling licensing framework so rights holders can collectively negotiate compensation for their work without incurring antitrust liability.
But deferring to the courts to resolve the fair use issue is functionally a massive stalling tactic that deeply harms creators. I mean, think about how the judicial system works. It takes years, sometimes decades, to establish firm precedent through the appellate courts and the Supreme Court.
That's just how the legal system operates, though.
Yes, but while the courts are slowly deliberating, AI companies are rapidly deploying models trained on billions of scraped copyrighted works and generating massive profits today. by the time a court makes a definitive ruling, the economic damage to writers, artists, and creators will be irreversible. The developers will have an insurmountable lead.
And the licensing frameworks.
The framework contains a massive caveat there. It says Congress should consider enabling them so creators don't get hit with antitrust lawsuits. But any such legislation should not address when or whether such licensing is required.
Correct. Because mandating licensing right now would drastically slow down the ingestion of data, which is the essential fuel for AI dominance.
So we just throw creators under the bus for speed?
If you force companies to individually license every piece of data on the internet before training a model, the U.S. loses the AI race to adversaries who don't care about our copyright laws. The framework provides a mechanism of collective bargaining without the heavy hand of a government mandate.
But by explicitly telling Congress not to require licensing, it offers creators incredibly weak leverage. I mean, if a developer isn't legally required to license the data, why would they ever voluntarily choose to sit down and negotiate a collective rights system? They won't. And this highlights a deeper tension in the framework regarding free speech.
How so?
The framework demands that Congress prevent the government from coercing technology providers to ban or alter content based on partisan or ideological agendas. It wants an effective means for Americans to seek redress for agency efforts to censor expression.
Which is a profound necessary protection of the First Amendment. It prevents the weaponization of AI platforms by the state. It ensures that the government cannot dictate or censor the information provided by an AI platform.
Sure.
Even in its protections against digital replicas, it explicitly demands clear exceptions for parody, satire, and news reporting. That's to prevent bad actors from abusing the framework to stifle legitimate free speech online.
I agree that protecting lawful political expression is vital. Nobody wants government-mandated censorship. But step back and look at the structural dynamic this sets up.
Okay.
The framework tells developers they don't have to license the data they train on. It tells states they cannot penalize developers when third parties misuse the models. It refuses to build a central federal agency, and it tells the federal government it cannot coerce platforms to alter content. You have designed a perfect system where the AI developers have access to all the world's data, incredible power to deploy it, and functionally zero liability or central oversight governing the outputs.
I'm not convinced by that line of reasoning because you are ignoring the targeted guardrails the framework absolutely insists upon. We discussed the Take It Down Act earlier, which creates a federal mandate to protect victims from non-consensual deepfake abuse. That is real oversight.
It's reactive, though.
The framework also demands that Congress affirm existing child privacy protections apply to AI systems. That includes strict limits on data collection for model training and targeted advertising when it comes to kids. It requires platforms accessed by minors to implement specific design features that reduce the risks of sexual exploitation and self-harm. It is simply false to say there is zero oversight. The oversight is surgical rather than a blunt bureaucratic instrument.
But surgical oversight is only effective if you have a capable surgeon in the operating room. By refusing to create a new federal rulemaking body and relying entirely on fragmented legacy agencies who are learning on the fly, the framework guarantees that enforcement of these targeted rules will be inconsistent at best and wholly ineffective at worst.
Well, when you look at the totality of what this framework proposes, I maintain that it provides a highly pragmatic, innovation-centric blueprint. If the United States is going to maintain global AI dominance, we simply cannot afford a 50-state regulatory nightmare, and we cannot afford a bloated new federal bureaucracy that fundamentally misunderstands the technology that's trying to govern.
Even if that means less accountability?
By focusing on targeted, specific protections like the Take It Down Act, age assurance for minors, digital replica laws, and the Ratepayer Protection Pledge, the framework addresses the most pressing harms without suffocating the industry. Furthermore, by utilizing non-regulatory methods to incorporate AI training into existing education programs and expanding workforce realignments, it ensures we are developing an AI-ready workforce. It is a roadmap for winning the future by removing friction.
I will readily acknowledge the value in several of the framework's targeted goals. Utilizing land-grant institutions to develop AI youth programs, providing technical assistance to small businesses, and protecting the public power grid while accelerating infrastructure, those are all necessary, positive steps.
Right.
However, the overarching structure of this policy framework is deeply flawed. by expressly preempting state liability laws that could hold developers accountable for third-party misuse, by flatly refusing to establish a dedicated regulatory body with the dedicated expertise to monitor frontier models, and by deferring the critical issue of intellectual property enforcement to the slow-moving courts. The framework leaves major, potentially dangerous structural voids in AI governance.
So you think it's too much faith in the industry?
Absolutely. It places an immense amount of faith in the goodwill of developers and the post-hoc capabilities of law enforcement to manage a technology that is evolving faster than any human institution in history.
Well, what we have ultimately uncovered today is the inherent, perhaps unsolvable tension at the heart of the AI revolution. I mean, how do you foster rapid, world-leading technological dominance while simultaneously implementing comprehensive, fail-proof oversight? This framework is not the final word on the matter.
Definitely not.
It is a crucial starting point for a conversation that Congress, the courts, and the public must continue to explore as these frontier models evolve.
I completely agree. The rules and norms we establish right now are going to dictate the trajectory of this technology for generations. There is so much more nuance to explore in this material, and how these recommendations actually translate into law will be the real test.
Exactly. We started this discussion talking about who is responsible when an AI system causes harm. This framework proposes that we shouldn't punish the architects for the sins of the users, and that the best way to secure the future is to innovate faster than anyone else.
The race is on.
But as these models grow exponentially more powerful, the challenge won't just be winning the race. It will be ensuring we don't lose control of the engine while we're running it at top speed.